Hi there, I'm Vanessa Carter,
And I'm Ray King.
and we work at Woods Rogers Van Dievener Black. Now, by now you'll have seen the first two videos in our chapter on residential and commercial real estate foreclosures, but we thought we would take a minute to talk together about all of the different tips and tricks that can come up in a foreclosure practice.
So the first thing is, if you are new to conducting foreclosures, residential or commercial, you need to be very adept at reviewing title and title reports, because that is going to be your roadmap to clearing hurdles to make sure you can proceed with the foreclosure. If it's a commercial foreclosure, it has been my practice that in addition to getting a commitment for a foreclosure sale, which lists all their requirements and exceptions, you also need to get all of the exception documents with your commitment and review them to make sure that there is nothing in the chain of title, reported in the chain of title, that is going to be an obstacle to your sale. And there are certain things that can show up in your title commitment that are either going to be stop signs that you need to stop and take care of, or speed bumps of something you need to take into account before you proceed with your foreclosure sale. The typical things that show up that you need to be aware of are mechanics lien filings, lis pendens filings, and unreleased deeds of trust. Your approach to solving all of these depends on the nature of what is shown in each of those documents, but they do need to be addressed. There are a couple of minds among attorneys in Virginia who practice foreclosure law about mechanics liens as to when a mechanics lien is in fact a stop sign or when it is a speed bump and just slows things down. Some attorneys are of the view that if the amount of the mechanics lien filing is de minimis compared to the value of the property and the loan on which you're foreclosing, you can proceed with the foreclosure sale so long as you announce the existence of the mechanics lien and the amount of the claim. Other attorneys take the position any mechanics lien filing is a stop sign and you must stop and you cannot proceed with the foreclosure sale until the mechanics lien is satisfied or released or bonded off of the property. What you do in each instance is going to depend on your comfort with the title and how to proceed and what your title company is willing to insure at the end of the day, because most purchasers do not want property with mechanics lien hanging out there, and you'll need to address the mechanics lien one way or another. As you know, the lis pendens is a notice that there is a lawsuit pending in that court which will decide some issue relating to the title of the property. So obviously this is critical in and will affect a foreclosure proceeding. So if there is a lis pendens, you're then going to need to find that litigation file in the court and review it to see what the issue is. And again, you're going to have to figure out, in working with the title company, if the property can be sold free of any claim in that proceeding, or will that proceeding, is it so critical that it is going to affect ownership and perhaps the lien of your deed of trust and must be addressed otherwise. The real estate records have lots of unreleased deeds of trust in them. There are many times in the not so distant past where there has been so much refinance activity going on that getting releases of deeds of trust recorded, it just didn't happen. So many times you may know that a deed of trust, an old deed of trust, is still of record but has not been released. If you have evidence of that deed of trust having been paid off something shy of an executed certificate of satisfaction, such as a settlement statement from a refinance closing showing that the deed of trust was paid off, you may be able to satisfy the title company and they would insure title of the property without taking exception. If you can't get that level of comfort with the title company, you're going to have to take some step to get the deed of trust released of record before you can proceed, unless the deed of trust is so old the statute of limitations has run on the enforcement of the deed of trust. The problem comes up when some of these old deeds of trust, the beneficiary of whom were lenders or lending institutions or banks that are no longer in existence, and you have to become Sherlock Holmes to track down who last owned that deed of trust to see if you can get a release. Sometimes you're lucky and it happens fairly quickly. Other times you run into a dead end and then you have to make a judgment call as to what to do. So learning how to spot title issues and following up on the ones that are problems with both the title company and deciding upon a strategy to address them is critical in your foreclosure practice. Now, as Vanessa mentioned, foreclosure law is the intersection of contract law, your deed of trust, Virginia statutory law, the statutes in Virginia that address foreclosures, and federal law, because you have all sorts of federal schemes that impact the liens and the loans and put restrictions or grant borrowers' rights on that proceeding. But that law has changed significantly in many respects over the last 10 years. So Vanessa, what does this tell us that we should be doing as foreclosure practitioners?
So just as a foreclosure practitioner would need to be adept at spotting title issues, reading title commitments, and negotiating with title companies, a real estate practitioner who is performing foreclosures would need to really stay abreast of legislative changes, anything that is about to be put forth. If you have a new revision to a code section that the Virginia legislature is contemplating, obviously that's something that you'll need to monitor and then respond to. One of a good tips that I can give foreclosure practitioners is to join a creditors bar association, who can also provide guidance and additional information on which bills are probably going to stall and which bills are, might become law.
Or the real estate section of the Virginia State Bar.
The real estate section of the Virginia State Bar is an excellent resource for this as well.
And I also make it a habit of make sure every July you take a look at the sections of the Virginia Code that address foreclosure and see if there have been any amendments.
Getting your forms updated is of critical importance, because remember, you've got some excellent consumer protection attorneys that'll be able to hone in on any kind of mistake or deficiency. If, say, there's a new section passed that requires you to include additional information in the notice of sale, by not including that, you open yourself as a foreclosure trustee up for litigation, and you open your client up for the possibility of needing to rescind a foreclosure sale.
So, Vanessa, you mentioned litigation. This is an issue that should be addressed in your engagement letter if you're engaged to be the foreclosure trustee for either a commercial or residential foreclosure. I highly recommend that in your engagement letter you include a provision in there that in the event you as the trustee are sued by a debtor or interested third party, typically the purpose of which is to stop a foreclosure sale, that the lender will defend you and pay for your defense in that proceeding. If you engage in this practice, either representing the lenders or as a trustee, you need to prepare to be sued. You are going to be sued. It happens. And you want to make sure you're covered by the lender to pay for those fees. This is not a claim against your liability, your malpractice insurance, but you want to make sure someone is paying those fees and it's not on your back. Sorry, Vanessa. Go ahead.
No, and what we talked earlier about, if there's any deficiency in your notice or any kind of error, I really recommend becoming friends with the clerk's offices and with the commissioners of accounts, not to correct errors like that, but to focus on, it's always good to be able to ask a favor of clerks if you needed something, a copy of a deed, or you need to learn more about a title issue. Then being able to call upon those folks is excellent in your practice.
Well, and if you have a question about what you need to include or something unusual that you need to report to the Commissioner of Accounts, something that may appear in your final accounting, it's always good to call the Commissioner of Accounts office and get their guidance on how to address it. It can ultimately save time in the long run, because if you send it down and they don't like it, you'll get a nasty note back and have to correct it. Whereas if you make the phone call and you've got a good relationship with them, they'll tell you how to do it and you get it right the first time. So being friends with the Commissioner of Accounts office is very good.
Now, Ray, I thought it would be good for us to take a moment to talk about the kind of the ethics of performing foreclosures. Not just the ethics, but the how do
you deal with it?
How do you deal with it? How do you deal with the fact that you might be, divesting a person of their home or their
foreclosing on the widows and orphans question?
Exactly. What how do we respond to that, and how do we operate in that world?
So foreclosing on real property that secures a loan, be it residential or commercial, is kind of part of the legal process for collecting debts that are delinquent. It keeps the intent partly is to pay off the debt or pay down the debt, but then at the same time keep the real property in use, to keep it part of the operating economy and productive for society. So as part of the process, it needs to be done, and it just has to be done.
Well, and we can see what happened to the real estate market when the foreclosure moratoria were in place, and how that kind of shook things up. So even though foreclosures are not always the most pleasant practice to be in when you're considering these issues, it is certainly a necessary service that needs to be performed. And by performing your responsibilities to the letter of the law, to the T, then what you can do is you can ensure that all of the appropriate steps are taken, and that you're serving if you're a foreclosure trustee, you're serving your fiduciary duties to the debtor, and serving that role well.
So that having been said, there are times when, as the foreclosing trustee, you may decide you have to say no to the lender and you are not going to proceed. These can come up in a couple of circumstances. They're rare, but they do happen. The first is where there is a technical default in the documents of some sort, but it's a real default, a real error, and it needs to be corrected before you can proceed. And even though the lender may be pressing you to proceed, you need to be able to say, no, we can't go until this issue is addressed to my satisfaction as the foreclosing trustee, and then I will proceed. You also need to be aware, it doesn't happen very often, but occasionally it happens, where you have a punitive lender, a lender who's foreclosing because they're at odds with the borrower and they are pressing for quick action or pressing a foreclosure where it's really not appropriate yet. And in those instances, in order to really fulfill your fiduciary duty as the trustee, you have to be able to say, no, I'm not going to do it. It may turn out you're discharged from that obligation, but that is the way to fulfill your fiduciary duty.
And of course, you might have a situation where an eager lender is looking to foreclose maybe right before a holiday. And you also need to be considerate of not only the optics of such a foreclosure, but also whether or not that scheduling would chill bids.
Exactly.
So I did want to talk to you, Ray, about some common issues that we see between commercial foreclosures and residential foreclosures. I know we both talked about title during our segments, But really, even within that realm of title, there are some issues that it's important to highlight, I would say. One of those issues is the idea of super liens that can jump priority. Ray and I talked to you about the importance of knowing your foreclosing liens priority so that you can advise your client, the lender, if you serve in that capacity, in what foreclosing position you would be in. But it's also important to be mindful that there are certain liens that can jump priority. When I say jump priority, I mean they can actually be required to be paid off before your foreclosing lien can be paid off. So one example is, like Ray talked about, mechanics liens have the opportunity to jump priority.
Either in full or partially.
In certain situations.
Yes.
Certainly UCC liens have the possibility of surviving a foreclosure sale. But in addition to that, there's condominium liens, which have super priority status over second deeds of trust. So just because you see the priority,
the recording
priority doesn't mean that that's how it will shake out when you actually go to the Commissioner of Accounts and submit your final accounting there.
Along the same lines is a lien that may not obtain a super priority, but will survive the foreclosure if you don't follow the correct procedures. And IRS liens fall into that category. A lot of times you'll do a title search and you'll see that there's an Internal Revenue Code lien recorded against the property. These liens, if you don't follow the procedures set out in the Internal Revenue Code, would survive the sale. In addition, there is an additional notice required to be provided to the Internal Revenue Service. The code section sets out specific information that needs to be included in the notice to the IRS, and you have to provide that to them well in advance of the sale, typically before your notice to the borrower goes out. The other thing to remember is if you have an IRS notice in the chain of title and you sell the property, even though you've provided notice to the Internal Revenue Service, the government has a 180-day redemption period during which they can purchase the property from the high bidder for the amount of the high bid. So this is something that you need to include in your announcement should you have an IRS lien filed in the title, so buyers know they're subject to being redeemed out by the government.
Now, Ray, is it common for the IRS to redeem properties after sale?
The IRS will typically only redeem property after sale if there is a lot of equity in the property between the bid price, the high bid, and the value of the property. That's when they're going to buy the property, because they'll buy the property for the bid price, then resell it or sell their redemption right to get the equity out of the property. If there's little or no equity, you will find that many times the Internal Revenue Service will waive their redemption right. And they may waive it before the sale, typically not, but they will waive it immediately after the sale once you report to them on the outcome of the sale, and they'll confirm it in writing, and then you can convey absolute clear title without the threat of a redemption to your high bidder.
And when we're talking about these tax liens, it's important to know the distinction between Virginia income tax liens that you might see in a title search and the federal IRS tax liens that we might see.
Yeah, so the state tax liens have the same effect as a judgment lien. They have the same priority as a judgment lien, and you would have to treat them exactly the same. So if you have a deed of trust ahead of them, they would be wiped out. But if you have excess proceeds after paying off the debt and the cost of the foreclosure sale, you may end up having to pay to the state or the taxing authority to pay off some of those liens. So depending on the circumstances, they'll either be wiped out or you may have to pay something toward them or pay them off.
So we talked a bit about super liens that could jump priority, and you and I talked separately about the importance of knowing priority, lien priority that is. What about subordination, Ray?
You do need to watch out for subordination of liens on property. It's not uncommon that there will be a deed of trust recorded against property. The borrower then borrows money from another lender, but one of the conditions of that borrowing is that the first lender subordinate their position to the new lender. So you'll have deed of trust recorded by the original lender. You'll have another deed of trust recorded by the later lender, and then you'll have a subordination agreement recorded that will either flip the priority of the liens or reorder portions of the priority of the liens. For example, it could provide that the second in time will actually have a first lien position for, say, $100,000. Then comes the original deed of trust, then comes the balance. And these are things you need to particularly pay attention to because it may mean you're foreclosing with a lien that would survive ahead of you. It may mean you have excess proceeds you may need to pay to another party. You can proceed on this provided you have a clear understanding of the priority and what is owed to whom. And if the banks don't agree, if they don't cooperate with you in telling you what is owed to who in what order, then you may have to file an aid and guidance suit, have court help you and figure that out.
Absolutely. And when we're talking about surviving foreclosure and wiping out of liens, what we're talking about is the process in foreclosure where after a sale, inferior liens that don't survive foreclosure are no longer attached to the property and would not need to be paid off unless there are surplus proceeds. So there are certain liens that survive foreclosure regardless. So one example is, real estate taxes. Of course, real estate taxes need to be paid at sale regardless of what position you foreclose in. Another example is, like I've talked about, UCC liens that might attach to personal property and would survive foreclosure there. Unexpired mechanics liens, another example of a lien that might survive foreclosure.
And let's go back up and talk about the UCC lien
Yes.
for just a minute. I talked about foreclosing on both the real and the personal property using the procedures followed in the UCC code. That sort of sale will wipe out the UCC security interest lien in the personal property. But you could be selling a residential property where, say, a mechanical contractor installed a new HVAC system, or a plumber put in a new hot water heater, and they kept a purchase money security interest in the equipment they installed. Typically, you're not going to sell those fixtures pursuant to the UCC code as you would in a commercial setting, and those purchase property security interests would survive a foreclosure sale.
Absolutely. And knowing how to call out the possibility of those liens at sale and knowing what to disclose is very important, I would say, in conducting your sales.
So you should always get a UCC search done with the State Corporation Commission on your borrower so you have a full picture of what's going on.
And when I conduct my residential foreclosures and I see a UCC lien on title, what I might do is contact that attorney who filed the lien or the company that filed the lien and request a payoff. That way I can know ahead of time what I might be in for if my client decides to purchase that piece of that security interest back. Knowing the payoffs of each of the liens that might come before your foreclosing lien in the title search is extremely important. But Ray, I think one of the differences between your practice and mine is that it is a great deal more difficult for a attorney to obtain a payoff on a consumer debt.
Much more.
That's due to all of the consumer protection laws that are in place and the privacy laws that are in place. It could be that when I'm conducting a residential real estate foreclosure, it could be that I don't know the exact amount of a payoff or a mortgage that came before my deed of trust. And in those situations, what I try to do is estimate, based on the amount of time that lien has been in place and what regularly scheduled payments would turn out to be. I try to estimate based on that what might be in store. But of course, after sale, you'll have a much easier time obtaining payoffs if you're the owner of the property and getting access to those payoff numbers there.
If you are foreclosing on a second deed of trust lien, whether it's a true second or a subordinated second, it is very important in your notice of sale and your advertisement of sale to include the disclosure that the property will be sold subject to a prior lien. I usually indicate the original principal amount of the prior lien. And if you can obtain a payoff, announce the amount at the time of the sale as part of your announcements.
Of course, much easier for you as a commercial attorney than me as a residential foreclosure attorney. I think you and I can both agree that some of the title issues that we find are the same for commercial and for residential properties. So, prior unreleased deeds of trust, that probably the bane of the foreclosure attorney's existence. Knowing when the deeds of trust expire is an extremely helpful tool. You might have, like Ray talked about, you might have deeds of trust that were never released from title, and now the lender is defunct or you can't get a hold of that lender. Knowing how to release that from how to determine whether or not that lien is expired can be extremely helpful for being able to move forward in the foreclosure process. So other title issues I can think of, missing interests.
Missing interests where the grantor only owned a portion, a tenant in common interest in the property, not all of it. In the commercial world, it doesn't occur, rarely, if ever occurs. In the consumer residential world, the missing spouse's signature on the deed of trust.
Very common to see a missing spouse, and if you real property law 101, if you have a husband and wife who own property and only one of those individuals signs the deed of trust, you've got a very real issue there with perfecting that lien.
You could have no interest or an interest only in a half tenant in common interest in the property.
Either way, your client is not going to be happy if you foreclose on that, I would say. I've also seen missing interest way back in the chain of title, particularly when there are estates involved. You have 16 heirs, but only 15 of them signed the deed. Often you'll see that called out on the title commitment, and it'll be listed as a requirement. Your title company will tell you, hey, get that fixed before you foreclose.
Right. So that either gives rise to a title claim under the lender's policy if they had a title policy ensuring a full fee interest in the property, or you'll have to chase down and get a curative deed that will correct the problem so you can proceed with your foreclosure sale.
Absolutely. And bottom line, having contacts in the title industry is extremely important. Again, joining the Virginia State Bar's Real Property section, you'll stumble upon so many title attorneys and have so many great contacts. But I mean, it's happened time and time again where I look at a title search and I see what I think is an issue. I'll call up my favorite title attorney and harass them and ask them, what might I do about this? Is this really an issue? How can I overcome it? Can I do this? Can I do that? So really having those contacts is an excellent way to further your foreclosure practice, wouldn't you say, Ray?
Yes, I agree completely.
Excellent. So we're talking more about types of title issues that will need to be resolved prior to sale. What about legal description issues? What can you say about that, if anything, Ray?
You can have lots of problems with the legal description issues. In reviewing the title, you want to make sure you have a complete, correct legal description of the property. You do run into instances where there may be a line missing in the legal description. This doesn't happen as much now as it used to. Word processing has solved some of that problem, but you do have that pop up. Occasionally you'll have missed calls where people just miss a call in a legal description. In those instances, the it being clause or source clause can be very curative, okay? And these are also issues to work through with the title company. Many times you may have a legal description with a meets and bounds that doesn't close, but everyone in the chain of title knows what the property is and the title company will insure it, and then you can proceed. I typically in that instance would advertise under both the incorrect and a complete correct legal description as to what I'm going to sell.
So Ray, you talked about missing calls. I once had a property that by the GIS map from the county website was shaped like a rectangle, but there were only 3 calls.
In the legal description.
And that's how I identified that title issue. As attorneys, we are not in the field,
We're not surveyors.
We're not surveyors. We are not. I can say that of all the foreclosures I've conducted, I've maybe actually visited maybe 1 or 2 after the sale just because I was in the neighborhood. So I don't typically go to review the property. You'll have legal descriptions if they're very old. Sometimes you'll have these meets and bounds legal descriptions which say, start at a white oak.
I've seen a lot of white oak references.
Start at a rod in the ground. We place a lot of faith in these metal pins that are put in the ground, but they can be dug up and moved. They can change place. So, knowing a good surveyor, I think, is an excellent idea. Knowing who to call upon when you've got a weird legal description that you can't figure out, I think is a good idea to have a surveyor on call who you can bother.
And most of the title companies have programs where they can plug in the meets and bounds calls to create a figure of the property to let you know if you really have a problem.
Exactly.
Okay. It is important to keep in mind that the baselines for doing surveys and descriptions has changed over the years. So just because the calls are different between 2 legal descriptions, that doesn't necessarily mean there's a problem with the legal description, but it's something you need to sort out. Because if the true north base has changed between 2 surveys, they'll have different meets and bounds calls in the description.
And I think when we're talking about describing the property, it's also very important that you include the right information in your description. If you've got a paragraph meets and bounds and you want to truncate that by using abbreviations, that's fine. But if you've got a less than accept paragraph saying 20 acres, less than accept 19 acres, you really want to make sure you include that less than accept information in that property description, wouldn't you say?
Because it would be significant.
It might be malpractice not to include it. So, yeah, what are we going to talk about next, Ray?
So, depending on the property you're foreclosing and the circumstances, this is could affect what you include in your advertisement of your sale, your notice of sale, and the announcements that you make on the day of the sale. We've already talked about perhaps an IRS lien requires certain notices.
Yep, subject to that IRS right of redemption.
If you're foreclosing on a second, you have to disclose the first.
I'd say sale is subject to all prior liens.
But I tend to be more specific in mine.
That's all right. We can disagree and we can still be friends.
It depends. Also, the type of property you're foreclosing on. If you're foreclosing on a condominium unit, obviously you need to have there are certain statements you need to make about the condominium regime and what you're closing subject to.
Foreclosing on a mobile home, if that mobile home is not affixed, you very much need to include information about that mobile home. Make sure that personal property is included in the
because
sale.
If it's not affixed, it's not realty.
Exactly.
So you need to pay attention to that. The other thing you need to do in your announcement is you indicate what the deposit is that needs to be made by your high bidder at the date of the sale. It used to be that it would always just say 10% of the high bid. And that may work in a residential sale, but in a commercial setting where you have a 30 or 40 or $50 million lien, and you could get a $25 or $30 million bid, 10% is not reasonable. So if I'm dealing with a reasonably large commercial lien, I usually indicate a fixed amount for the deposit that has to be made by the high bidder, so the bidders know how much to bring. And there's a fine line that you need to balance in setting the amount. You want the amount high enough that it will discourage a high bidder from walking away from the sale if they get cold feet a day or two after the sale. Mm-hmm. But you don't want it so high as to discourage bidders from coming to the sale and bidding. So you need to think about it, set it appropriately, and include it in your notice.
And I think when we're talking about the bidding process, we know that it can take many different forms, such as a call-in, if you allow folks to dial in, say from New York for your
Yes.
your special commercial property. Being able to be a little bit flexible with accepting those phone bids might mean that your final highest bid is a lot higher. But that being said, you also want to make sure that you're not accepting, phone call bids from people that haven't demonstrated that they're an active, interested party.
You don't want someone colluding with the borrower.
That's absolutely not something you want. You don't want the person who is placing the bid to then walk away, meaning that you'll have to perform the foreclosure all over again.
Usually at your expense.
Usually at your expense if you're the one making those risky calls.
Yeah. So everyone knows that the lender, the beneficiary of the deed of trust, has a right to submit a written bid one time.
Yes, and that can be total debt, meaning they just want everything that is owed, or they can specify an amount. That's maybe much less than the amount owed. And why might a lender accept less than what they are owed?
Well, before a lender undertakes a foreclosure, they're going to do an analysis on the value of the property. They don't want to overpay it. Mm-hmm. Okay, so they're going to set their bid accordingly. So it is not uncommon to receive from your lender a written bid a day or two before the sale that you'll have in your file, and after your announcements and you begin bidding, you'll announce that bid. It's important to know that the lender can submit only one written bid, but the lender is not limited to only making one bid. Okay. Out-of-town lenders routinely use written bid offers. Mm-hmm. It avoids them having to come to the sale. I typically will have the lender on the phone if they want to be on the phone at the time of the sale. There are great benefits to doing this. They hear the proceeding. They know how the bidding is going. If the lender decides they want to increase their bid, they can. And they hear what the price is knocked down at the end of the sale. So there's a lot of benefit to doing that. I also regularly accept calls from bidders who I've vetted in advance, so you know they're real bidders, and let them bid over the phone. We've already made arrangements typically to have them make the deposit by a wire transfer if they're the high bidder. They've already been cleared for that. And there's a reason to do that, and it's in order to satisfy your fiduciary duty as the trustee. You have the duty to maximize proceeds of the sale for both the lender and the borrower. So bringing in additional bidders that can get a higher price for the property helps you fulfill that duty.
Now, Ray, I've had this happen a few times where a lender has asked me to bid on their behalf at a foreclosure sale for a prior lien on the property. That's another example. You might receive phone calls as a foreclosure trustee from other trustees saying, my client is interested in bidding. Will you waive your bid deposit? And I think being able to make those kinds of judgment calls is also important, whether or not to waive bid deposits, like we talked about, whether or not to accept call-in bids, and how to navigate the fact that your client may be thousands of miles away while you're conducting this very important foreclosure sale.
So it does happen, and I've had it happen several times, where you're getting ready to start the sale and you get a phone call from a bidder who's late. They're in the car rushing to the sale, and they still want to bid. So you have the opportunity to either, if it's someone you know, let them bid at that time, or as the trustee, you have the discretion to suspend the sale for 15, 30 minutes or an hour to allow a potential bidder time to get there. And as long as you're announcing what you're doing, there will be no opportunity for anyone to complain about the process because you're just working on maximizing the proceeds of the sale.
And talking about complaining about the process, trust me, you as the foreclosure trustee don't want to be late to your own sale.
No, because the sale will not have occurred and you've got to start it over.
It's best to be on time, especially in our situation where we're in tidewater and there's lots of bridges that will stand in your way. Well, Ray, I've had a lot of fun talking to you about foreclosures, and I wanted to thank you for being
Vanessa.
in the video with me.
Thank you. We hope you found these tips, ways to stay out of trouble, informative to you, and good luck on your foreclosure practice, whether it be residential, commercial, or both. Thank you.
Join the real estate section of the Virginia State Bar.